Good morning, everybody. As you can see, I'm a real master of the technology here. I'm Richard Glover, and you will soon be seeing the excellent Cain Ormondroyd as well. And welcome to this latest in our series of webinars, this one on matters concerning local authorities, rates and the COVID virus. We were approached after the webinar of the 21st of April to adjust it specifically for a local authority audience, and that's what we've attempted to do. In particular, we've added a section on grants, which local authorities have to manage by reference to rating criteria, and a section on the risks to authorities in the process, and that at the expense of a section on material changes of circumstances. So it was inevitable that yesterday we received a pre-question and it was on material changes of circumstances. I will try to deal with that from Roger Messenger in the question and answer session at the end, which leads me neatly into a reminder about how communication works or doesn't work in this process. Your only way of engaging with us is by posting a question using the question and answer Q&A button on your screen. Please do so. The plan is that we will have about 45 minutes from us. That's quite flexible. On the 5 topics that you see on that screen, and then a question and answer session to take us to the end of the hour. The first of our topics is the responsibility of Cain, who, as you will know, is both a fellow editor of Ride and the leading junior currently at the bar on rating matters. So it's now over to Cain when I stop sharing my screen and mute my microphone.
Thank you, Richard, and hopefully everyone can see my my slides there. So yes, occupied and unoccupied premises in the context of COVID, and really the purpose of considering this is that there are clearly lots of ratepayers out there who've been affected by the virus in various ways, but who may not be eligible for one of the reliefs that we're going to discuss. Particularly, I think, office occupiers. They may have been severely hit by the coronavirus. For example, if their business forms part of the supply chain or is otherwise ancillary to the hospitality and leisure sector. So they may have had a big impact, but they won't receive any relief on rates payments as far as the office is concerned. Alternatively, there may not be anything to do with hospitality or leisure or any sector that's been particularly hit, but they may have had their ability to use and or occupy their editament itself severely impacted. So, for example, if it's in a location where it's dependent on people coming in by public transport, or if it's in a location whereby all the surrounding services which people working there would normally use have shut down for COVID-related reasons. So that's the sort of high scenario that I'm thinking about, and I understand from various people at billing authorities that those sorts of ratepayers are the ones pushing to try and seek to have their editatements declared unoccupied, and therefore they get then a period of relief, or rather exemption. So assume then an office entirely shut down, and we'll just look at some relevant principles. The first case here, Associated Cinema Properties, was a case about reserve offices in the Second World War. And that may be a good starting point, because we're always told that the response to coronavirus is, quote, unprecedented in peacetime. So, perhaps let's look at a wartime analogy. And the company had taken a lease on a house so that it could use that house as offices if its main offices were hit by a bomb. Now there was no furniture or chattels in the house, but it was ready for occupation as an office, really at a moment's notice. But it was held that intention to occupy in the future was not sufficient to constitute occupation now. So the simple fact that someone plans to resume using the office when lockdown is over, that in itself will not suffice to put them in occupation. The next case takes us from wartime to holiday time. It concerns a seaside shop, Southend-on-Sea, which was only used in the tourist season. The stock was taken out each winter, but it was held that the items remaining on the premises were sufficient to mean that the shop operator was in occupation throughout the year. Caution about the facts, because as we'll see in the next slide, there's now a specific statutory provision which probably covers furniture and so on. But what that establishes is the principle that storing items between periods of active use may constitute occupation. So in the hypothetical example of this office that's shut down during lockdown, if there's something stored there, then potentially that may mean that it continues to be occupied. And we've got to contrast that case, Southend-on-Sea, with cases where items are left on premises, but really they're of no value, and they're left simply because it's too much trouble to remove them. That category of cases might be analogous to sort of personal belongings of employees left in an office that's been shut down by the employer for lockdown. The employer is the occupier or potential occupier, and from the point of view of the employer, those sorts of the mugs, the photo frames, the pictures, and so on pinned up in the office are going to be of really not very much value at all, and certainly not worth the trouble of requiring people to remove them. So I mentioned statutory provisions, and there is a specific provision in the Act which requires one to disregard plant, machinery or equipment in two scenarios. Either that plant, machinery or equipment was used in the Hereditament when it was last in use, or it's intended for use when it's next in use. So in our example, hypothetical example, the office owner might well say, they would say that both of those, that any plant, machinery or equipment in the office falls to be disregarded under either or both of those limbs. The way that statutory provision functions is one applies a but-for test. So, but for those items, would there be occupation? So, in other words, you completely disregard the plant, machinery, and equipment. You imagine it wasn't there at all. It's not a question of saying, well, okay, the plant, machinery, and equipment by itself can't constitute occupation, but that together with something else can do. You simply take that out of the equation altogether. Now, plant, machinery, and equipment would clearly include, well, clearly in my view, would include computers, phones, office equipment, printers, things like that. The court in Sheafbank and Sheffield accepted without any apparent unease the agreement of the parties that it also covered furniture. That wasn't subject to any arguments in the case, and it may be challengeable to some extent because the categories of plant and machinery imply something that's, as it were, in active use rather than merely being decorative or as it were, passive use. So there may be scope to argue that that equipment should be construed in a way that puts it in line with plant and machinery. So that's an area of potential argument there. But apply that to our empty office. The computers, desks, chairs, filing cabinets, phones will all be disregarded. Personal bits and bobs of the employees probably don't suffice to put the office owner in occupation because they're not sufficiently valuable to him. So that really leaves us with sort of stored files and documents. And the query there is whether there are sufficient amounts of those things stored to constitute occupation, and that I think will be a fact-specific assessment. The rates avoidance case, Richard's case, macro, established, you remember it was about files, pallets of files being stored in a vast warehouse. And although the amount of files stored was very small, the court said, well, there is something there. These files are of documents which are legally required to be retained, and the occupier the occupier intends to be in occupation. So put those things together and you have sufficient for occupation. Now, clearly in macro, it was in the occupier's interest the owner's interest to be in occupation. In this scenario, the occupier will presumably turn around and say, well, no, I have absolutely no intention to be in occupation at all. So query whether in that situation, where there's no intention to occupy, you may find that whatever files or documents are stored are not sufficient to put them in occupation. So there is a credible argument there in respect to my hypothetical office that the erstwhile occupier is no longer in occupation, although it's not straightforward and it won't be automatic. It's going to require assessment. I think another angle on this would be in respect of computer equipment, if that is still in use in some way. So if the computer servers are there in the building and those are somehow being accessed remotely by people who are working from home, that potentially will ground an argument that the office is still in use and still being occupied. And if it were still in use, then that equipment wouldn't fall to be disregarded under this statutory provision. So that raises some interesting questions, and it may depend on really what those arrangements are and how whatever equipment there is on the premises relates to the home workers, or perhaps the actual servers are off-site and people are accessing those those from home without necessarily any interaction with the office premises. So I think that there is an argument, and I think that we will probably see litigation on this as ratepayers seek to minimise their liability. I think I'd stop sharing my screen now and turn back over to Richard for the next topic.
Hello again. There. So forgive me. I am not as adept as Cain is on dealing with the technology. And as you can see, I am still on the almost seamless, don't you think? Apologies. I pick up from where Cain left off with the assumption that that which we're dealing with is unoccupied. Now, as you know, the Unoccupied Property England regulations of 2008 identify in Regulation 4 classes of hereditament which don't give rise to liability to unoccupied rates. And I'm going to say a few words about two of them, those that are on the screen, C and D, whose owner is prohibited by law from occupying it or allowing it to be occupied, and D, the hereditament is kept vacant by reason of action taken by or on behalf of the Crown or local authority with a view to prohibiting the occupation of the hereditament. The first point to make is that because the relief is given anyway for the first 6 months of non-occupation of industrial hereditaments and 3 months of other hereditaments, the application of these provisions is only likely to be a live issue if the non-occupation extends beyond those periods. So in many cases, these questions will be academic. The second point I wanted to make is that it seems to me that in our circumstances, the effect of COVID and the restriction regulations, I doubt that D adds much to C. We are concerned here with the provisions of the regulations requiring people to close premises during the emergency period. And it seems to me that really comes into the prohibited by law ambit. The third point is that because the application of subparagraph C is very fact sensitive, it is not that easy to talk generally about the points without, frankly, being a little more than banal. So, but the task is to identify the tests which the courts apply. And we start for those purposes in a case that isn't actually on the screen, which is Tower Hamlets and St. Catherine's by the Tower. It dates back to 1982. The building didn't have a fire certificate, and there was a particular statutory provision which provided that in those circumstances, the building was not to be occupied. And the legislation provided for enforcement of the prohibition by penalty. The High Court decided that the owner in those circumstances was indeed prohibited by law from occupying, and rejected Tower Hamlets' argument that a court order was required before we got to the stage of prohibition. In the next case, which is Westminster and Regent Lyon, next case I want to talk about, I'll turn back to Hailbury Investments, which is on the screen. Westminster and Regent Lyon is actually in 1990. The hereditament was in builders' hands for refurbishment, and asbestos was found. A prohibition notice prevented any refurbishment work, and that refurbishment work was required to enable any occupation. the prohibition notice prevented that work until the asbestos was dealt with. The court asked itself and then answered the question being where the effect of a prohibition notice is proved to be that the hereditament may not be rateably occupied until some steps have been taken. Is its occupation prohibited by law? And the answer was yes. Where the effect of that notice was that the hereditament couldn't be rateably occupied until steps were taken, its occupation was prohibited. In Hailbury Investments, that is on the screen, the House of Lords held that the existence of planning conditions which would have been breached if the hereditament was occupied as offices, that condition did not mean that the hereditament was prohibited from occupation. It could, for example, have been occupied for another use, and in that case, the other use was residential. And finally, on the cases, in Pall Mall Investments and Gloucester, more recent, 2014, occupation of the vandalised office building would have been in breach of the owner's health and safety obligations, but nonetheless, the owner was not prohibited from occupation. The health and safety legislation did not prohibit occupation, nothing less than an explicit prohibition would suffice. So what do we get from these cases is a pretty clear steer that for the exemption to bite, then on the facts, all occupation must be prohibited. The risk that occupation would lead to litigation, for example, for a breach of a planning condition or health and safety requirement, wouldn't be enough. Now, those requirements, in my view, may be difficult to meet in the COVID context. And the two main reasons for that are on the side. First, the provisions need to be sufficiently stringent to prohibit occupation directly or by necessary implication. And secondly, there must be some doubt whether the relief is applicable, where there are potentials for alternative use, and specifically so far as COVID is concerned, where there are specific exemptions in the regulations, for example, for broadcasting from closed theatres or the use of hotels for homeless accommodation. But it does seem to me, on the other hand, that there may be some cases which on the facts could get through. For example, if a pub could not, because of its layout, be occupied for any other purpose than as a pub, it seems to me that the restrictions contained in the COVID regulations do amount to requiring that that pub is not occupied for the purposes of a pub, subject to the points that Cain made earlier about equipment, furniture, and so forth. So there's a little introduction, maybe to spark some questions on those particular exemptions for unoccupied property. The next topic, which I'm afraid again you have me for, concerns reliefs and grants. And I have on this screen the reliefs and grants on which I'm going to touch. In all cases, for reasons of time, the English provisions. The overarching aim of government, it tells us, is that retail, leisure, and hospitality properties that have to close under the restrictions, and indeed shops that do not have to close, will benefit from the relief. So it may be that my pub example a little earlier is academic, because this relief is available. It's becoming a habit with this government to make substantial changes to rates liability without any change in the legislation. And the mechanism for the widespread COVID relief is that the billing authorities, so not the government, but the billing authority, will grant hardship relief under Section 47, which means, importantly for this audience, that authorities will not be able to grant relief to themselves. So you, the local authority, will use your discretion to grant relief under Section 47, and then central government will reimburse authorities for the actual cost to them under the rates retention scheme of the relief which falls within the definitions in this guidance. So you decide whether the relief is applicable, and then the government will reimburse you for the actual cost in respect of those grants made that do fall within the definition of the guidance. That's very different from saying that the grant will cover local authorities for the damage done to their rates revenue by the COVID crisis. Because if, for example, there are reductions in values that are achieved through material change of circumstances proposals, it seems to me you're not going to get repaid for those reductions in revenues, the consequent reductions in revenues that follow as a result of this relief. The relief is 100% discount of rates liability for 2020-2021 for so long as the hereditament continues to meet the criteria. So that's the limitation. It's not the length of the emergency period under the COVID regulations, and there is no rateable value limit to this relief. So what are the criteria? The main ones appear on this slide. The guidance gives fuller details of what government considers to fall within the broad headings, which are identified there, shops, restaurants, cafes, etc., etc. And they also give indications of what they consider do not fall within these headings. And so singled out as not falling within them are amongst other uses, banks, building societies, osteopaths, solicitors, and financial advisors. I'm going to pause not on the nature of the uses, but on the terms highlighted on the slide: occupied and wholly or mainly used, either for the provision of the years of the nursery education or for the uses of shops, etc. Hereditaments which have closed, dealing first with the occupied heading, hereditaments which have closed temporarily due to the government's advice on COVID-19 are to be treated as occupied for the purposes of the relief. But if a shop, for example, closes because the economic fallout of COVID means that a retailer reduces the number of its branches, then the relief will cease to apply. The criterion whether a hereditament is wholly or mainly used as a shop, restaurant, etc., is a criterion related, as it says, to use and not specifically to occupation. There is quite a lot of learning on the phrase wholly or mainly used, most of it in cases where billing authorities have attempted to deny charities charitable relief, because the test there is whether the hereditament is wholly or mainly used for charitable purposes. An example is a case called Kenya Aid, but all of these cases are fact sensitive. So again, it's not that easy to generalize at a level that's other than banal, but the courts have indicated that the test involves looking not only at the purposes of the use, but its extent or amount. Thus, in the Scottish case of the English-speaking union, the fact that the upper stories were unoccupied weighed against the union's argument that the hereditament was wholly or mainly used for charitable purposes. The ground floor was, but the vast majority of the heritage, as they call it, the hereditament, was unused and so not used for charitable purposes. If there are going to be, in the COVID context, cases about wholly or mainly used, or issues about wholly or mainly used, I expect that the debate will probably be about the comparison between used and unused parts. I move from rates relief to grants that are allied to the rating assessment in some way or another. It is a recurring problem that local authorities have to manage the detail on behalf of a government that, well, doesn't really do detail. And it does seem to me that the grant guidance is in part, and understandably, hurriedly drafted and not always clear. Government says that it will reimburse local authorities that pay grants to eligible businesses in line with the eligibility criteria in the guidance. But those criteria are not always easy to apply at the margins. To give one perhaps esoteric example, paragraph 11 of the guidance for business says that eligibility for grant depends on the claimant's hereditament being eligible for small business rate relief or rural rate relief. But paragraph 11 of the guidance for local authorities describes eligibility as being for all businesses in receipt of the rates relief. In most cases, the distinction between eligibility for the relief and being in receipt of the relief will be a distinction without a difference. But it may be troubling where, for example, the hereditament has a nil value because it was in builder's hands and the VO hasn't yet re-amended the list. So the rateable value is under the threshold set by these reliefs, and so eligible for the relief, but not in receipt of any relief because there is no liability to be relieved from. And on that particular point, there's a balance to be drawn, and as paragraph 16 of the guidance reverts to eligible, I tend to support that particular interpretation for what it's worth on that narrow point. The second half of this slide moves me on from general introduction to the reliefs to talk about in particular, the Small Business Grant Fund. As the digression I've just been on indicates, a peculiarity of this grant is that although it's payable to businesses, eligibility for it is governed by occupation of a rateable hereditament. And the guidance tells us that businesses which are not ratepayers in the business rate system are not included in this scheme. There are two sets of criteria for this grant of £10,000. I should just note on the slide that the £10,000 that is at the top there relates specifically to the small business grant, as we will see when we come to the next grant, the one for pubs, shops, pubs and so forth. The figures are slightly different, but so far as SBRR is concerned, £10,000, and there are two sets of criteria, one related to the small business rates relief scheme and the other related to the rural rates relief scheme. I'll summarise both, starting with that related to the small business rates relief scheme. The key date here is the 11th of March 2020. That is the date on which you are to apply the criteria. And the two main tests are on this slide, and together with the requirement that the business be not in liquidation. There's no intention to pay grant to businesses that have failed before the COVID emergency hit. The first of those conditions, section 43(4)(a), applies. And because we're talking about section 43, we're talking about hereditaments which are occupied, though the shops, for example, that are closed because of COVID are to be treated as occupied. And so the issues that Cain mentioned earlier are for these purposes dealt with in that way. And 43(4)(a) applies where a condition prescribed by the Secretary of State is met. Currently, that prescription is that the hereditament's rateable value be less than £51,000. But that element is pretty much redundant because the criterion relating to the value of E in those pithily named regulations order of 2017 sets a much tighter rateable value limit. Under that order, as I read it, E, which is a number that is identified in the regulations, will not be greater than 1, which is the requirement for the grant. So the requirement for the grant is that E is greater than 1. And E will not be greater than 1, as I read it, unless, first, the hereditament's rateable value is less than £15,000, and secondly, the subject hereditament is the only one in England occupied by the ratepayer. There are exceptions and caveats to the requirement that the hereditament be the only one occupied by the ratepayer, but we don't have time to go into those details for the enthusiast. They're in Article 3, paragraphs 7 and 8 of this 2017 order. But the result is that one is looking for this relief at hereditaments that on the 11th of March 2020 were occupied and had a rateable value of less than £15,000. Perhaps I should have got to that slide earlier. The grants related to rural rates relief, these are hereditaments to which section 43(6)(b) applies, again on the critical date of 11th of March 2020. And hereditaments to which that provision applies are also eligible to the small business rates relief grant of £10,000. This time, £10,000 per qualifying hereditament. And to qualify, the hereditament needs to be in an identified rural settlement, to fall within one of the types of property to which the relief relates, So these are qualifying general stores, food stores, post offices, pubs and petrol filling stations, and to have a rateable value below the relevant prescribed amount. And I think it's 12,500 for pubs and petrol filling station and £8,500 for other hereditaments. And the final requirement, as indicated on that slide, to qualify for the relief, yours needs to be the only one hereditament of that type in the identified settlement. I move next to grants for the hospitality and leisure industry, and the main criteria for this grant are on the slide. If those criteria are met, the sum of the grant, forgive me, will depend on the rateable value of the hereditament. If the rateable value is £15,000 or lower, then the grant is £10,000. But between 15,000 and, well, I say between above 15,000 and less than £51,000, the grant is £25,000. The criteria are summarised on this slide. Rateable value. Now, of course, the discount rate relief scheme that I discussed earlier didn't apply on the 11th of March 2020. The question is, though, so far as this grant is concerned, that if it had, would the hereditament have been eligible for it? And again, this rules out the billing authority's owned property. A hereditament which warrants the grant I've just been looking at, the small business grant, cannot come back for a second bite at the cherry. Next, the hereditament involved has to be a business occupation, so it doesn't apply to private beach huts or stables or private stables or matters of that sort. That's the intention of that not occupied for personal use criterion. Again, businesses in liquidation aren't going to get a grant. Specifically, car parks and parking spaces are excluded. And there is to be one grant per hereditament. So what about rating list changes? We're being asked to look at the position of the rateable value on the 11th of March 2020, but what about if that changes? And these are quotations from the government's FAQ paper. Any changes to the rating list after the 11th of March, including changes which have been backdated for this date, should be ignored for the purposes of eligibility. Forgive me, the way this is set out on my screen is the block which has my unpleasant face on it is covering some of the words. So let me get it on some other source. However, in cases where it was factually clear to the local authority on the 11th of March 2020 that the rating list was inaccurate on that date, local authorities may withhold or reward the grant based on eligibility had the list been accurate. This discretion is only intended to prevent clear errors. Any decisions made after 11th of March 2020 should not affect eligibility. It seems to me that is not a particularly clear steer from government. We start with ignore any changes, and then we have, well, maybe not all of them. But it seems to me that the general rule is to take it as it is, take things as they are on the 11th of March 2020, and ignore subsequent list changes unless the wriggle room needs to be applied to avoid some sort of injustice. This final slide on grants before I return you to the safekeeping of Cain. It is about the local authority discretionary grants fund. I'm not going to go into this in detail. An extra 5% of funding is, we're told, going to be allocated essentially to address those small businesses which fall outside the two main grants. A government gives general criteria in guidance papers, but mainly encourages the application of local knowledge and local discretion. What this is not, as compared with those two that I've looked at in a little more detail, what it is not is related to rateable hereditaments. Indeed, particular examples that are being looked for to be covered here are office sharers who don't have a rating footprint and bed and breakfasts that pay council tax. And with that, it's back to Cain for the risks that local authorities face with COVID in context.
Thanks, Richard. Yeah, so risks to local authorities. On this slide, I've focused really on some of the risks which are within your control or your ability to control to some extent. A major risk that you face, but which you can't unfortunately do really anything about, is the familiar one of changes to the rating list. And there's a specific issue as to whether or not ratepayers may be able to establish a material change in circumstances based on the virus and the response to it. Now, Richard's going to touch a bit on whether and to what extent that those attempts might be successful later. But what we do know is that there have been widespread attempts to establish that and potentially large ramifications then for your revenue and your budgets. And there's it's a familiar frustration, but there really is very little that can be done about it other than to make some provision in the budget. The main risk within your control arises from the way that the relief and the grants are structured. As Richard's explained, the relief hasn't been written into legislation, so it's not as it were a legal right for people to receive it. It's formally a discretionary relief, but subject to reimbursement by grant from the government. Similarly, the grants are for you to pay out and then are reimbursed by the government. But the government promise to reimburse only extends to relief or to grants which have been given within the terms of the government guidance about eligibility. And as Richard said, that guidance itself is not always the clearest, and it has been necessarily put together in something of a hurry. So there's a clear risk there that if you step outside the terms of the guidance, or are deemed to have stepped outside the terms of the guidance, that you'll be left bearing the cost of the relief or the grant. At the same time, of course, there's a huge amount of pressure the other way to get this relief and these grants sorted out very quickly. And local authority officers I know have been really working round the clock to deliver that, particularly on the grants, which is just a completely new responsibility which has been given to local authorities. So the risk will always be that some auditor will query actions taken now in the heat of the crisis, with the benefit of hindsight, with lots of time to consider it. They'll comb through and consider that certain things are outside the terms of the guidance. So that is a risk to be aware of when you're trying to process these things. I want to focus now on another specific risk which relates to state aid. Now, although we've left the EU, as we have left, the terms of the transitional agreement mean that we do remain subject to state aid rules, and the European Commission retains the ability to launch and complete state aid investigations. So it's not at all the case of an irrelevant system which has been consigned to the past and can be ignored. The government has made it clear that it doesn't think that the relief amounts to state aid. Presumably that's justified on the basis that it's not selective, or not no more selective than the nature of the measure requires. So it sort of benefits everyone rather than certain undertakings specifically. The grant, on the other hand, is considered by both the government and the Commission to be state aid. So one has a sense really of a sort of political deal between the government and the Commission, where they say, okay, well, we'll leave out the relief but put in the grant into your regime. We'll never know whether that's what happened or not, but that's the feeling one gets. The opinion of the government and the Commission that the grants are state aid, reached in respect to the scheme as a whole, isn't determinative, and there's case law to say that an individual recipient can still argue that that something is not state aid when the commissioners sort of deem that it is on a whole scheme basis. So ultimately it's for the local authority making the payments to decide whether it's giving state aid or not in any particular case. Now, clearly in 90%, 95, 99% of cases, it clearly will be. It's money paid by the government to assist a business. The terms of the grant scheme are effectively selective because they only benefit certain rateable value properties. So in the majority of cases, it clearly will be state aid, but it may not be. And I think that will depend really on the recipient, and there will be certain recipients who don't meet the criterion of being an economic undertaking. So if they're not providing goods and services into the market, if they're providing these for free or doing some sort of charitable or cultural activity, then they may not meet that requirement or that definition of an economic undertaking. Or if they are providing goods and services, they're doing that in a way which which by nature serves a local market only, with no possible implication for trade between member states. Again, in that case, it wouldn't be state aid within the EU regime. So, I mean, that would need careful analysis on a case-by-case basis to determine whether the payment is state aid or not in any case where it was challenged. If it is state aid, then there are certain thresholds which mustn't be exceeded, either the well-known de minimis threshold, or if that can't be used, there's a specific provision for COVID-related aid approved by the Commission. The main additional requirement there is that the recipient was not an undertaking difficulty, so that COVID isn't being used effectively as a cover to prop up businesses that ought to have failed. So where is the risk here? Well, you will not know what other state aid the recipient has had, either by way of grant from other local authorities in respect of other hereditaments, or from other sources of state aid entirely. Similarly, you won't know whether it's an undertaking difficulty. And that's why the government guidance recommends getting a declaration from the recipient. However, the process of obtaining those declarations is cumbersome, and given the pressure to be proactive and to support businesses, various local authorities have, I understand, been paying out the grant and then asking for the declaration afterwards. or clearly if the declaration arrives and it's all in order, then that's fine and no problem. But what if the declaration doesn't come? Well, presumably there'll then be no right to recover the money paid out from the government because, as I said earlier, compliance with the state aid regime is one of the conditions of the grant in that guidance. So then you're left looking, well, can we recover this from the recipient? Can we force them to pay it back if they don't want to? And I think it's not actually, surprisingly, it's not clear whether you could do that. If the payment's been sent out unsolicited, then it's not a question of fraud. The recipient hasn't sort of lied to get their hands on the money. And it's hard to say that the payment has even been made as the result of a mistake if no attempt was made to discover whether the recipient would meet state aid criteria or not. It's simply gratuitous payment. And so there doesn't seem to be any obvious cause of action in English law whereby you could recover it. There has once been a claim for recovery of state aid, of overpaid state aid, which was subject to an application to strike it out on the basis that, precisely that basis, that there was no known cause of action in English law to enable that money to be recovered. Those proceedings became academic for other reasons before that issue was resolved. So it's very much an open question whether the courts in England would recognise a cause of action. I've flagged a Scottish case in which the Scottish courts have recognised it, but in any event, it would require breaking new ground in England, and that's not normally a position my clients want to be in. To add a further level of complexity, the Commission also has extensive powers to direct government to recover misused aid. So if this does become a big issue, then local authorities may be pushed by central government to take some form of recovery action. So again, that's not a position you really want to find yourself in. So I think it is replete with risks, and it will require very careful thought as to how to handle any exposure to this issue by way of declarations that haven't been returned. So much for the slightly grim topic of risks. Now, as I say, for something completely different, which is a bit more fun, and that's about courts and tribunals. If you share my particular sense of fun anyway, about courts and tribunals in lockdown, and just doing a quick rundown of how the different courts and tribunals are coping. The VTE has not coped particularly well. It's essentially postponed all hearings until after the end of June. There's still no, as far as I know, no indication what will happen after that. The VTE itself is fairly frustrated by this, and it sees, from discussions on the user group, the president essentially takes the view that it's not able to hold remote hearings by video or other means because of the form of the procedure rules. And unlike other courts and tribunals, which we're going to come on to, those procedure rules haven't been amended. So it's left a bit stuck. The only option available to it really is to deal with things in writing. And that is an avenue that's been taken on a fair number of appeals, mainly involving local authorities. So you may have been involved in one of those cases. Let us know in the questions box if so. But that's a route that it can only take by consent of the parties. So there's a real hold up there, and it's not clear at all how it's going to be resolved. The upper tribunal, on the other hand, mainly here just by way of example, because mostly you wouldn't be involved in things in the upper tribunal, is really, is more of a model case of how to respond well to lockdown. There were very prompt amendments to the rules to allow broadcast of video proceedings, so that the public could be involved that way. Expand the scope of private hearings and recording. The tribunals come out with practice direction, guidance. So it's really, and the messaging very much is, we are going ahead as normal, and hearings will proceed. And Richard and I were just discussing that the technical arrangements for that don't always quite keep up. Skype for Business and so on can be a bit challenging. Certainly, we've both got a hearing there a week today, so we're hoping that the technology will hold up to allow us to deal with that matter. The Magistrates Court is one which I expect you will be very familiar with. There's guidance on the criminal jurisdiction, which stresses that there is a need for flexibility in terms of allowing people to attend by remote means, but the overall message is that trials are likely to still have to be conducted in person. Listing, it stressed, is a judicial function on a case-by-case basis, so it's up to the the magistrates or the district judges to decide on how things should be listed on a case-by-case basis, and priority must be given to custody cases and cases which are otherwise sensitive, and then everything else comes below the various priority categories. Contested rating matters, or even relatively uncontroversial rating matters, are therefore likely to be a low priority, and I've heard various horror stories of sort of basically things being adjourned to 2021 simply because courts cannot find the time after they've used their sort of limited sitting time on custody cases, sensitive cases. They just don't really have any time for anything else. But the practice does seem to be very variable and ad hoc, which so it may vary very much depending on your local area. But essentially, for substantive hearings, likely to still be in person. If you are faced with a remote hearing, then there are some tips here. Whether we're in a position to hand out guidance on the use of remote technology, you can judge for yourself after hearing this webinar. The crucial thing, I think, is preparation, especially if it's unfamiliar. Check the technology's working. Bundling and document control, which are particular passions of my sort of OCD mindset, are particularly important, because you can't just show the document so easily, or point to things, or see what document people are looking at. There has to be an agreed bundle with pages, and it all has to be well presented. I think it's a real advantage to have separate screens, so that you can have the tribunal on one screen and your notes on or any documents on another, and certainly a separate keyboard, so that the screen doesn't shake violently whenever you type. A great idea is to have a separate communication loop for the team, so that you can engage in the tribunal on the screen, but also then communicating with the team by email or WhatsApp. And as far as advocacy is concerned, or addressing the tribunal, brevity is very much a virtue, because these Zoom or online hearings, forums can be quite draining to engage with for a long period of time. And I think that's probably a good note on which to draw the presentation part of the webinar to an end. Thanks for listening to that. And now I think we may have some questions.
Seeing as we've overrun, Cain, it's also a slightly brave note on which to end the presentation part. But we apologise for that. We hope it has been bearable for you. We do have 7 questions. I think we can rattle through those quite quickly. I say 7, we actually have 8 because of the one I mentioned earlier that came in yesterday from Roger Messenger. So shall I address that first? The context is of local authorities themselves considering the possibility of making material change of circumstances appeals in respect of their car parks, leisure centres, libraries and so forth. And the 2 questions are these. First, is the existence of relief to others good evidence to support a valuation effect of an MCC where no relief is available? I think, Roger, my response to that is to send it right back at you, because it seems to me the question here is a valuation question. You've identified an MCC. What is its valuation consequence? And is the fact that other people in a similar sector, leisure, for example, are not being required for this year to pay rates, something that would affect the rent that the hypothetical tenant would be prepared to pay for your local authority leisure centre? I don't say that as a matter of necessary logic it either does or doesn't have relevance. Whether it does, it seems to me, is a matter of valuation judgment. And the second question is the reopening of non-essential retail from this Monday a second MCC? And to that, my response is potentially yes, but it may well depend on the hereditament you're talking about. So it's not obviously an MCC in relation to the valuation of a football ground that certain shops are now open in the town centre. But it may well be an MCC for example, the car park in the town centre. So that's my response to the question raised by Roger. The next one, Cain, is for you, Stephen Ward, and then there's a clutch for me, and towards the end there's another 1 or 2 for you. So could you deal with that one? And Stephen Ward said, sorry Cain, my connection isn't the best. Please could you confirm whether office furniture, desks, chairs, phones, printers, etc. constitute occupation?
Well, I think the answer to that will depend on whether they're in use or not. If they're not in, if the building's not in use, then those items would all potentially fall to be disregarded under the provision in the statute that I mentioned on the slide. So if you've got a building that's not in use, that those items probably will not mean that it is occupied, and you'd have to find some other basis to say it was occupied if that's what you wanted to argue.
The next 2 I think I can take together from James Collins and Geoffrey Waters. First, James's client was fitting out their shop, and when COVID struck and the regulations struck and the works were delayed, they hoped to open in August, September. Will they get the rates relief when they open? And Geoffrey's is about a new occupier taking a lease on a retail unit later in the year and meeting the qualifying criteria. Will they get the relief for part of the year? Always worse before answering or responding to questions like that to say I haven't gone back in detail to to check the chapter and verse on the guidance. There haven't been time for that. But so please do that before just acting on what I have to say. But my understanding is that the eligibility is assessed and calculated on a daily basis. So for any day in which you qualify, you qualify. Next one is also from me, from Jerry Sherder. For the purpose of the expanded retail relief, the guidance states establishments which have closed temporarily due to the government's advice on COVID-19 should be treated as occupied for the purposes of this relief. What happens, Jerry asks, when, for example, the government allows hotels to reopen, but the owner does not reopen immediately because it's uneconomic to do so until public demand recovers? Is that hotel still treated as occupied for the purposes of the expanded rate relief, or is it no longer closed temporarily due to the government's advice on COVID-19? Never an easy question from Jerry. Jerry, my immediate reaction is to say this is likely to be another of those cases where ratepayers are going from foot to foot as to whether their eligibility or whether their minimizing of rates liability is best achieved by saying they're in occupation or they're not. I think you do quote correctly the guidance, and the guidance is closed temporarily due to government advice on COVID are to be treated as occupied. Once government advice on COVID does not require closure, it seems to me that on the simple words read crudely and not necessarily in context, that particular exception to the rule ceases to apply. But it becomes important, so that those issues don't need to be addressed, to get yourselves in a position where even if you're not open to the public, you're in a good position to say that you are occupied. Joe Hunt, again for me, and this is a grant question. If small business grant is paid and a business has another hereditament, which is a market stall, would an additional grant be paid under the RHLG? This is, I think, getting us into those two paragraphs in the 2017 order about those circumstances when something else, when the occupier occupies more than one hereditament. And there's an exception, for example, where the other hereditament is less than has a rateable value that is relatively small. I would not want to go nap on this question in this sort of environment, but my instinct is to say that it is quite possible that a second grant could be payable. And finally, Cain, over to you for Paul Wade's question.
Yeah, so Paul is asking about recovering relief already given, which is a slightly different. I was talking in the session about recovering grants, so where the authorities actually paid out money. Paul is asking about a situation where an office occupier has said that their office was unoccupied. That was accepted by the local authority at the time, but the local authority has now gone back on that, or is trying to go back on that, and say, no, actually we think that this building was occupied all along, and he's asking, can they go back on this decision? Well, I think in principle, the local authority isn't bound by its earlier decision. You might try and take judicial review proceedings against the new decision if there was something particularly unfair about the way that it had changed its mind. But I think probably for practical purposes, the only way or the best way to try and to try and stop the local authority changing its mind would be to rely on the case law about late service of demand notices, because in order to change position, they're going to have to serve it. They'd have to serve a new demand notice, and that will be after the time when that demand notice should have normally been served for that period. So if you can establish that there's been delay, which there has, which is greater than reasonably should have. Sorry, the notice has been served later than reasonably practicable, and here you could argue, well, we told the authority what the situation was. If they wanted to take issue, they could have taken issue then. They've left it till now that reasonably it was practicable for them to have gone into this earlier. But that isn't enough in itself. You'd also have to show that that delay has caused you some prejudice, and that may be where there's more trouble, because ultimately, if the decision is yes, it was occupied, then you're really not paying anything more than you ought to have paid all along. The argument for prejudice would perhaps arise if you could show that you would have done something else within that time if you'd known that the authority was disputing what you said about occupation. So lots of issues there, and those are the principles to apply. The final question, I think, is also, well, there's a final question of asking me what is an undertaking in difficulty, and that's defined in Article 218 of the General Block Exemption Regulation, it is quite a complicated definition, but basically it's looking at various indicators of the financial health of the business, and how its losses relate to its share capital and so on. So that would require sort of careful application of those specific provisions about what is undertaking difficulty. The most obvious example will be something that's in insolvency. That's an easy one. That's the easiest one to identify, but that's the sort of thing that's been got out there.
I'm glad you dealt with that one, because that's been on the list for a while, and kept getting shunted down beyond other ones on our list. I don't know quite how the mechanism is doing that. There is finally a question from Paul Tyrrell for me. If a shop and a pub next door to each other both claimed prohibited by law, would the purpose of the business be the deciding factor? In my view, the deciding factor is whether occupation is prevented. So an issue on a shop, for example, would be that it may be that for a time occupation of a shop for one purpose was prohibited, but for others was not. Then it seems to me an issue with whether one can say that particular shop was ever prohibited from occupation by law. But in both of these cases, so it's a question of the facts, whether there's some form of occupation that could be achieved. But in both of those cases, one would expect the relief to be available in any event for this year. And so these issues may well not achieve a greater pecuniary benefit for your client than that relief already achieves. And there's a final very specific question about whether a shop that has a membership scheme should be barred from the extended relief. Although I can immediately turn out the provision in the guidance that I have in mind, or I can't, and I think the answer is that I can't. But there is a provision in the guidance that touches on, it's paragraph 17, They set out types of uses that the government doesn't consider to be an eligible use for the purpose of this relief. Hereditaments that are not reasonably accessible to visiting members of the public. And it says no more than that, but there is going to be the question in respect of a membership scheme, whether the hereditament is reasonably accessible to visiting members of the public. Thank you all very much for your questions. Thank you, so many of you, for staying on even beyond our allotted time. We hope that that has been useful to you and has beguiled a lockdown morning. We are now going to sign off and say thank you very much. Thank you and goodbye.
Thank you. Goodbye.